Yes, good morning, Miss Brown.
My lords, my lady, good morning. Would you wish me to introduce everyone in the courtroom or identify largely where the relevant people are?
Well, I know who everybody is in court. Lady and my lord may not, but they can probably work it out. So let's crack on. The first thing I wanted to ask you was, have you had a chance to discuss the timetable for today? We cannot sit late today, Miss Brown, because we have to attend the swearing in of the new president of the family division.
Yes.
So we can't sit beyond our usual time, but I don't imagine you're going to be. I imagine you're going to be able to finish well within the day. What have you discussed?
We have discussed the division of time, my lord. You can see the order we're sitting in, which is that Miss Moore, for the Guardian, Children's Guardian, is sitting with the Council for Local Authority at the end, because the Guardian does support the appeal.
Parts of it.
Parts of it, but it supports the invitation to this court to set aside the judgment. And so we considered, subject to the court's approval, that Mr Goodwin may wish to address the court after Miss Moore.
All right.
And so we sit in that order, and it's our view that I am likely to take up the longer time initially, not least to deal with the issue of which judgment we are actually.
Well, that's the second point on my list.
It is.
Of things to ask you about. But anyway, what is your timetable, roughly, so we can?
So our timetable is that we would complete my submissions, any additional submissions by Miss Weston on behalf of the father and Miss Moore, comfortably before lunch.
Good. That sounds good.
And then that would leave Mr Goodwin, who anticipates he might be up to 90 minutes, being able to conclude within good time for our appointment later.
Yeah, all right, thank you very much. That's the first point. That's helpful. And then the second point is the judgments. Now, we received yesterday something called an approved judgment.
Yes, perhaps if I can explain it in this way, the judgment under appeal is the judgment that was delivered extempore on the 20th of February 2026, and the transcript of that is within the core bundle.
Right. So let's just get that. So.
And that's it.
It may well be, I don't know, that other members of the Constitution have replaced that with the latest version. But you say that is the one that's at page or tab 8, is it?
Tab 8,
yeah. Page
77.
Yes.
And it goes through, and it is 175 paragraphs.
Yes.
I read somewhere that the judge refused expedition of the transcript. Am I making that up? Or?
Well, there was a.
It's a short question.
It's a short question. It's not entirely correct. We asked for expedition, and I think the answer was given, which is always given, which is there's no such thing as expedition anymore.
I'm sorry, I asked.
So it wasn't refused. I don't wish to level that.
Okay, okay, and how does it come about we had this other document yesterday?
What happened was that there was that transcript, the page 77 transcript, was sent to everyone, and then there was a case management hearing on the 9th of March of 2026. The only trial counsel who was at that case management hearing was Mr Goodwin on behalf of the local authority, and the other parties had different representation. And at that hearing, the judge asked for some of the evidence relating to her questions to the father to be read out to her.
Sorry, so this, yes, just say that. Would you mind to say that again? So I'm going to take a note of this.
Yes,
so
on the 9th, case management hearing on the 9th of March. So by that time, the oral permission to appeal had been made at the conclusion of the judgment on the 20th of February, and our grounds of appeal and application for permission, and indeed the father's, had been submitted to this court.
And appeal notices to this court.
Yes.
Yes.
And at that hearing, the judge asked for a note of the questions she had asked the father at the conclusion of his oral evidence to be read out. And what then happened was that following the hearing on the 9th of March, the judge sent an email to all trial counsel saying this: I've virtually completed reviewing the transcript. There is just the note of the father's evidence. You read out your note.
Is this written down somewhere?
It's not,
Okay,
I'm
well,
afraid, because I didn't
go dictation. I virtually.
completed reviewing the transcript. There is just the note of the father's evidence. You read out your note of that in the hearing. Would it be possible to have an agreed note and I can finalise the transcript?
Yes.
Miss Weston, King's Counsel on behalf of the father, replied to that email and said this. She asked if the judge was making changes to the judgment under Practice Direction 30A 4.8. And
What does that say?
what that says is that where the application for permission to appeal is made to the
Hang
lower
on, let me find
court.
it. Do I need? Is this a case where I need to get some emergency red books, or is it just okay if I look it up? PD 30A.
PD 30A 4.8.
Yes.
Because PD 30A deals with a material omission from a judgment of the lower court, and 4.8 deals specifically with where the application for permission to appeal is made to the lower court. The lower court may consider whether there's a material omission and adjourn for that purpose if necessary.
Okay, I'm just getting stuck into. We don't need to get stuck in this, but isn't this relating to appeals within the family court?
Yes.
We're not in the family court.
No. But well, that's right. And of course, whether we get into the issue of functus at that point.
Anyway, so Miss Weston asked if it was under.
Whether the proposed amendments were being added pursuant to 4.8. And said this is Miss Weston's email: I am not aware that the court considered it necessary to address material omissions in light of the applications for permission to appeal that it reviewed. I am similarly unclear of the basis on which the court is now seeking to make additions to the judgment, but acknowledged, in brackets, although there are of course circumstances in which clarificatory addenda may be appropriate.
Yeah.
And then said this, and this is relevant to the two documents we have. In the circumstances, please could the court ensure that any additions to the transcript of judgment are clearly marked, for example, by the addition of an addendum paragraph rather than changes to the body of the judgment which the court gave.
Mm-hmm.
And then we turn to the 181 page judgment.
Yes. I
And-
spent 2 hours last night going through that,
Yes.
and I marked up in my copy of that electronically by highlight the changes.
And
And I emailed that at 11 o'clock to my colleagues.
what
So I think we are all aware of exactly what changes were made.
yes, and I was going to begin by going through those changes, but I don't need to. I need
It
to
will
address.
take a long time.
It would.
The basic position is that most there were many changes which are just typographical
Yes.
corrections, but there were other changes which represented an amendment of the judge's reasoning.
Yes.
And that seems to be subject to anything Mr. Goodwin may say.
Yeah.
So so what follows from that?
Well, what follows from that is that it illuminates the grounds of appeal. That we say that the judge's reasoning, the deficiencies in the judge's reasoning are such that the judgment just simply has to be set aside. We say it's impossible to discern the basis for the decision made by the judge because the reasoning is so deficient.
Can I ask a question? When did the revised judgment become available? Is it the date given at the top, 10th of March?
It was, and
So it's been available for
It
a
has,
couple of months.
it has,
And when I read, for example, the skeleton filed on behalf of the local authority, they make references to paragraphs in the judgment, and that appears to be the one of the 10th of March. Is that correct?
Yes.
Yes. But what I don't see is in some of the other skeletons are references to paragraphs in the judgment, or
Yes.
any discussion of the way in which this judgment came to change.
yes, because it was sent through by the judge on the 11th of March in an email in which she said, herewith the approved transcript, I'd be grateful if it could be sent on to the Court of Appeal. And so we all worked on that transcript believing that the only additional paragraphs were the two that were highlighted.
So why?
Even though there are, sorry,
When was it sent?
I was going to say, even though there are 181 paragraphs compared to 170 something.
Yeah, well,
Yes.
that if you go through it, you find out that some have been taken out and some have been added. So it's
Yes.
it's knit one pearl one in some respects. So it's do you just but when did did you finish your point?
Yes, I'm sorry.
What is the when did you've had it on the 10th of March? When was it sent to us?
Well, and this is,
Uh,
there is an error.
Yesterday seems to be.
Yes, well, I believe we notified the Court of Appeal about it last week, but in
Okay.
terms of being sent, because we needed permission to send it. And
All right.
we
Well,
made
how are we going to proceed? Which judgment are we going to proceed on today? One view would be, I haven't discussed this, obviously, but one view would be that notwithstanding the points made by Miss Weston, we should treat the latest version as the version which the judge, after corrections, set out intended to reflect her reasoning. Should we not proceed on that basis?
That is our position.
Yes.
We say that this is the judgment that the judge wished the Court of Appeal to be considering in the appeal that she knew had been made. I think by the 11th of March, I can't recall what date, it was prior to permission being granted.
Yes.
So
I mean, that would be, don't you agree? I mean, maybe we need to go and talk about this.
That's the pragmatic answer, it's
Do you
not the
agree?
right answer.
Should we talk about this?
Maybe we should leave it open.
Yeah. Okay, well, let's see how, it's okay, well, without coming to a firm, that's what I've said is one view, and that's certainly been a view that was expressed to me when I found myself in your position many years ago in front of Lord Justice Thorpe, and this is the same thing had happened. But I think we'll keep it, we won't reach a definitive view about that, because it may be you want to make submissions arising out of the alterations. Happy with that?
But indeed, my lord, because although I say this is the judgment, the very fact of those changes shows the problems with the extempore
Well,
judgment.
that was the point you made about it illuminates the fact.
It illuminates it, and effectively they stand together. There are a number of ways of describing this, and to answer my lord's question about how long we'd had it, I accept that there have been failings by certainly myself in terms of doing the job of work that we ended up doing, but we did make assumptions without looking at them line by line.
Yes. Yeah,
Which
well, this now explains that your submissions are basing on one judgment, Mr. Goodwin's on another judgment.
yes, and indeed because
Version
our
of it.
skeleton arguments are in fact on the note of judgment, because they.
But there were skeletons in support of the application
Yeah.
for
Yes.
permission to appeal. I mean,
Yeah.
they've not been perfected for the
No.
substantive appeal. Really.
They've not, because there was no direction
There-
for that to be
No,
done.
there wasn't.
by
For some reason.
Lord Justice Peter Jackson,
Right.
that there was no permission for that to be done because they cover the grounds, that the only direction was for the consolidated grounds.
Right.
appeal.
Well, anything you want to say? Anything that you want to say? Okay. All right. Is there any other preliminary matters you want to raise? We need to think about before we get into the meat of the issues.
No, my lord.
Okay. What are you inviting? If you succeed, what are you inviting us to do?
We say that the matter. We say the matter has to be reheard. The only hesitation in my saying that is that, of course, my lord will know from the chronology that there was the consideration prior to the fact finding as to whether or not it was necessary for there to be one. But the local authority's position is clear. They do not accept the evidence of Dr. Dickens and her opinion, her medical opinion, and they say that the injuries do need to be litigated within a fact find. Therefore, there would need to be a rehearing.
Is that everybody's view if the appeal is allowed? Miss Mormont has a slightly different position on because we'll come to that. But basically, is that agreed? If the appeal is allowed, it has to be a rehearing.
Yeah, and we would invite this court to keep it within, not limit it back to Luton, but to keep it within the division. So it's before a High Court charge.
Well, we'll see where we
Yes,
are.
and it may be that the appropriate course is for it to be.
It would be Mrs. Justice Arbuthnot, wouldn't it?
Yeah.
Right. Okay. Thank you.
And I'm very grateful to my lord having
Well, I can
said.
tell you that we've read all of the core bundle and we've had some of us looked at some of the original material, particularly the medical reports, but that's what we've read.
And I am going to begin with what I say are the significant changes to the judgment that was delivered on the 20th of February. And I begin, do my lords and my lady have the 11th of March judgment as a separate document? So
Yes,
should I
yes.
refer simply to paragraph numbers?
Yeah,
Because I don't think.
yes, okay.
Thank you. First of all, paragraph 21. At this stage, it's the same paragraph numbers because we haven't got added in paragraphs. So this is comparing it with page 82, paragraph 21. And what is added in there are the words "and should be considered"
Yes,
after.
that's right.
And I say this: why did the judge consider it appropriate to add that in when she did not say it? And what we say is that she did not engage with the parents' evidence
Well,
and explain her conclusions.
I'm not going to interrupt every so I'm trying, but she does say the evidence is important. So if she says it's important, can't one assume that she's going to consider it?
Well, that's right, and whether what she's doing by adding in "and should be considered," which of course is right, it should be considered. I'm not saying it's wrong but she didn't say that, and we say she didn't properly consider. And adding in those words certainly does not amount to a consideration of the parents' evidence. It does not amount to an evaluation of the parents' evidence on any of the disputed issues. They're just additional words that she felt necessary to put in the light, we say, of the grounds of appeal. And then she adds in at paragraph 22, it's the last line, each parent knows the other one and each says that the other parent would not do anything like that.
Yeah.
which of course is not setting out exactly what the parents said, it's just a summary, which again adds very little, but we say is indicative of her, whether it's an acknowledgement that she hadn't properly addressed exactly what the parents had said in the course of the fact finding.
But again, isn't that reiterating in different words what she said a few lines up?
Yes, it is, and these ones are not necessarily of particular significance, but where I say they're significant is that they show that the judge, in what she said perfecting it, was trying to show to this court that in fact she had addressed the parents' evidence. And likewise, and it's these 3 points together in the early parts of it, at paragraph 23, where she adds in, I say this in the context of the parents
no.
not having to prove anything.
I've missed this.
Yes,
What
that's
is
in the
it?
middle of the page,
Sorry.
middle of the paragraph.
Yeah. What do you say is
At the
different?
bottom of page 82, we have, in fairness, that is not the way the parents put it. And for the avoidance of doubt, again, I say this. And then she goes on to that parents are very often asked to think what would cause the injuries.
Sorry, I
But
missed that.
she adds in, I say this in the context of the parents not having to prove anything.
Which you would say is rather more significant.
My lord, yes, and we say that the judge adds that because she knew that part of the grounds of appeal were that she had effectively reversed the burden of proof. She also adds in there, just in case my lord missed it, having missed that previous sentence, equally unsurprising,
Sorry,
2 lines down.
but forgive me, Miss Brown. It was late at night. Last year. Yeah.
The next part that I would alight upon is paragraph 34, where she simply italicises.
Yes, can. I didn't do that last night, but I didn't notice that she italicized it.
And presumably for emphasis, I mean that's why one changes the font or changes how a typed words are. And of course we know that she can, in terms of in law, she can depart from the opinion of a medical expert. But of course our point on appeal is that all judges have to correctly set out the opinion of medical experts, and in order to then make a reasoned decision to depart from them. We say that she's failed to even do that in this judgment.
It's quite interesting that she bothers to put italics around can, but doesn't bother to correct, I have to have sound evidential evidence,
Yes,
whatever that means.
whatever that means, my lady, yes. If this had been a wholesale perfection of an extempore judgment, it might be different, but actually the small additions are very telling.
Well, I noticed doing the comparison even more swiftly than my lord had time to do it, that there are lots of other typos that haven't been corrected.
Yes. Yes. So it's we would say that we can see what was in her mind in the work that she did in submitting this judgment to this court to be the subject of this appeal. We then, after this point, because she creates a new paragraph 39, we end up with different numbering for the paragraphs, and that's just a straightforward.
Yes. Explain to my lord and my lady. All I did there was I highlighted the paragraph number to indicate that she turned it into 2 paragraphs.
Yes.
So 39
Yes.
was originally the end of 38.
Yes, and so we she adds in, and I'm sure my lord found this, there are some minor amendments, but she does add in because of illness in terms of being late for judgment in
Where's that?
paragraph, in the new judgment, paragraph 48.
Okay, well, let's just have a look at that. Did I see that? No, I didn't see that. That doesn't matter, does it?
But again, it's having put that in when there hadn't been a wholesale amendment of a whole range of other issues within the judgment. It's as if it's I'm not certain. I would be speculating as to why that's done, and I make no point about it.
Yes, right. I don't think we should be end up time to speculate on these sort of things. I think we need to get to the meat of if you're going to focus on the changes, you need to focus on the key ones.
Absolutely,
Otherwise
and
you're gonna run out of
the
time.
next significant changes in the new judgment, paragraph number 54, comparing with 53, because this relates to the findings or that not making a finding in relation to the pinch to the ear, which was part of the local authority's case. They were pleading that they were seeking a finding that the father had pinched the girl's ear, and in paragraph 54 there is a boy's ear. Did I say the girl's name? I do apologise, I didn't even hear myself saying that. I'm being corrected, it was the boy's ear.
Yes.
Paragraph 54.
Well, we'll try not to mention the children's name.
Yes, and I've explained to the parent that, to the mother, that we mean no disrespect to refer to a boy and a girl, but because of the live stream.
Yes.
The change is this. I make no point about removing on the Western Front.
No.
It's at the end where she adds in, so nothing, and again,
It's a typo.
it's a typo, but she adds in with a typo, so nothing was for him made that particular night stand out.
Yep.
And again, we say, well, why was the judge, in perfecting this judgment, adding anything in about that incident? We had included, and it's paragraph 37 of our skeleton argument in support of permission to appeal, that the judge had failed to consider this part of her analysis against the findings that she did make, because she was not making a finding of an injury to the girl's ear, but was making the other findings. So we say that the judge knew there would be some scrutiny by this court of her analysis in relation to the ear incident. So it seems that she wanted to add something in there for this court to consider. There are some minor changes in paragraph 55, again, which I do not take issue with. The main addition that I make the point, it's an additional paragraph at paragraph 57. It is not highlighted, despite the fact.
It is on my screen.
Yes, but in terms of how the judge sent it, we have the final page where she writes, there are additions at paragraphs 146 and 147, which I have highlighted in yellow
Yes.
at the request of counsel for
Yeah.
each of the parents.
Yeah.
She did not highlight this paragraph in yellow. It is an entirely new paragraph. And all she does in this paragraph was set out the local authority's case, setting up her analysis about the bruising and whether it was disproportionate. She does not, in adding this paragraph, had she followed it with an exposition of the parent's case, I might not be making a submission about it.
Yes.
She
refers to location and lack of explanation in the last phrase of that paragraph, and that theme reappears in further amendments
Yes.
in due course.
Yes, and of course, by putting it in this way without setting out the parents' case, because the parents' case was not based on location, was not based on lack of explanation. And the judges simply omitted that throughout the judgment. She doesn't set out, she heads it in respect of the other injuries which I come to in turn. The local authority case is not based simply on the frequency of bruising, but doesn't set out any part of the parents' case or any part of their evidence. She adds in, and I'm sure my lord saw this at paragraph 66,
Yep.
the setting out that she needs to consider specific events because they have to be disproven by the local authority. I'm not quite sure why that was added in. And then at 68 we have the next significant change, and it's one that has to, we're comparing with paragraph 66 on page 93. She removes part of her paragraph 66.
Yes.
And she removes the whole section, but that does not quite stand with what the mother was saying, with the need for the doctor's appointment, because if he bruises easily, and what was being said was he bruises easily and inexplicably, she was placing the responsibility, if I can call it like that, on the stairgate. It is not easy to understand why she felt the need to consult the GP for an escalation in the bruising, and replaces that with, but that does not quite stand with what the mother was saying and with the need for the doctor's appointment. If he bruised but there was an explanation, i.e. the stairgate, it is not easy to understand why she felt the need to consult the GP for an escalation in the bruising,
Okay.
for which she felt there was no adequate explanation.
Yeah.
And
I mean,
sorry, my lord.
no, go on.
This is a fundamental change. First of all, because it's not in keeping with the evidence, written and oral, and we say that change was made by the judge to shore up or backfill the conclusion that she had reached, that the only period of unusual bruising was in September 2024.
Sorry, would you mind repeating that? Shore up or backfill?
Or backfill to support the conclusion that she reaches in the judgment that the only period of unusual bruising was in September 2024. What it does do by making that change is it makes her judgment consistent with the error that she's already made in paragraph 5 of the judgment, unchanged, where in setting out, and I would ask my lady to go to paragraph 5, because this is the opening part of the judgment, where she set out and made her first error. At the start of the process, the mother took Arlo to the GP because she was concerned about the level of bruising and said it had escalated and were unexplained from her perspective. But of course we know, and it's within the chronology in the core bundle at tab 6 at page 68. That the mother's online request on the 8th of September for Arlo sorry, I do apologise, that would be
A.
boy, was
Yes, we can read that.
you can read that it's about bruising very easily and some bruises without injury. So it's easy bruising and unexplained bruising.
Okay.
And
Is
that
this passage? This passage is not set out in the judgment, is it?
it is not. No, because it's an error. Because the only reference to easy bruising is the part that she excised in perfecting
Sorry.
the judgment.
When you say it's an error, what do you mean?
An error by the judge, because the judge has never, within the judgment that she has perfected, it's fundamental to her evaluation that this was unexplained bruising in September.
I think what you're saying is that insofar as that's alluded to in the form of paragraph 66, it's excised from the new paragraph 68,
Yeah.
if I've understood you.
Yeah, my lord, yes, and it's excised, and it's hard to understand why it's
So
excised.
what might have otherwise have been an allusion to, for example, this note, disappears from the final judgment.
Yes, and paragraph
which
5
odd.
is incorrect where it does refer to it.
Okay. Right. So this was arguably in the first version of judgment alluded to, Lord's phrase, in the first version of judgment, but it excised from the second. I mean, when I compared the two, I mean, this is, I don't want to spend all day for my part analysing the texts, but I hadn't read the amendment to be that significant. So it may well be, a stronger point is that this note on page 68, as recorded, which you say is accurate, presumably, is something which was not taken into account by the judge at all.
My lord, yes, and it really is. By going through these changes, it illuminates the points we make in our grounds of appeal, because of course it's also linked to her failure to properly record the foster carers' evidence, which
You're coming on to that.
we properly set out within our submissions. First, and it's in the supplementary bundle at 61. At tab 4, and it's within the third bullet point with the points within that bullet point, where the judge is reminded that the foster carers' written evidence.
Sorry, I'm in the wrong place.
Tab 4 was
Tab 4
It's a little bundle,
the
little
little
supplement.
supplement.
Sorry,
I think we've
my mistake.
misnamed various
Don't worry.
bundles as well.
page
It's 61.
61, big pardon, sorry.
Right, you got it. You've got a small bundle.
This was sent through electronically, I think. We've not been, we won't give them
Has
paper
anybody got a
copies.
spare copy of the supplemental bundle they could release for Lady Justice Andrews quickly, please? Or are you all working off screen like the modern lawyers you all are? If you don't mind, share with me. Share. Why don't you use mine? I'll do it. But you go with that for the moment. And I'll go.
We'll get Taryn to
I'll ask Alice.
two.
Right. Just give me a moment. I'm just going to ask my clerk for another copy.
Thank you.
Joe.
Which page is this?
61.
Of which bundle?
The 109 page bundle. What's now 100? It was originally 99. Now it's 109.
So that's
Okay.
your document.
Yes.
Yeah. Okay. Let me just email Anna. Just asking her.
It's good to get in touch with you. Arrived.
What?
Hard copy if you've got a hard copy.
it's 100 and, how many pages? 900
9. 109 pages.
109 page bundle supplement.
But it comes from two sources. There's the original bundle sent through for 99.
And there's
I
already-
didn't even get the original bundle, otherwise I
And
would
it's-
know
Yeah.
about it.
Anna's dealt with all this, so she'll know. I can ask Emma because she's been around this track for a bit.
I apologise for
Well, what? No doubt in a few years' time, everyone will be on screen, so that we won't have this problem. Okay,
I wish I
right.
brought my computer.
Right. Okay. So let me just give me a moment to find this. Yeah. Go on. What's your point?
it's within the submissions about the bruising, and then in the third bullet point, and then the matters within it, where I'm listing the gaps in the evidence relating to bruising, and I set out 1, 2, 3, 4, 5, 6, 7. That the foster carer explained that the boy sustained bruises for which he could not provide an explanation, and then I put in quotes from his written statement. The boy has bruises that no one can say where they come from, and then I add and oral evidence, because that was confirmed by the foster carer in oral evidence.
Thank you.
And of course, the other matter here, just while we're in this bundle, that it was a significant part of that submission that if one turns to page 10, which is the schedule, chronology of bruising,
Yes.
there was the bruise on the 1st of August to the back of the thigh, which there was no explanation.
So your previous, just so my notes absolutely right. Your previous submission was related to paragraph 37 of your submission, was it?
37, yes.
Yes. And now we're on page 10 of this bundle.
Page 10, which is within our document, which is submitted with our written submissions.
Yeah.
And it's that bruise which was unexplained in the foster care, that occurred in foster care.
19th or 26th?
This is it's page 10 of the supplementary.
Yes. What date of the...
Oh, 1st of August, 25.
Oh, I'm in the wrong place. Yes, I see.
And of course, my lords, my lady know that there was a bruise to the back of the thigh in the child protection medical that formed part of the 12 bruises at that stage that were observed on the boy, that formed part of the interim threshold. By the start of the fact finding, the local authority were only seeking findings in relation to 5 of the 12. And then by the conclusion of the submissions, they did not seek a finding in relation to the thigh bruise, the back of the thigh, that was observed in September of 2024. And within our submissions, we make the point that presumably, because if that was unexplained in August in the care of the foster care, it didn't help the local authority's case to pursue a finding that that was in fact inflicted. And I digress from where I am on the judgment, but it underpins the points that we make about her analysis. And that follows through with the additional changes that relate to the bruising 83, paragraph 83, the judge adds in at the beginning of the paragraph, so one also looks at other occasions when bruising could occur in the normal course of day-to-day events. And I pause to add in here that, of course, central to our submission is that, of course, she didn't look at the whole of the bruising, because we know there was bruising when the children remained in the care of the parents under 24/7 supervision, which formed the basis for the removal of the children from the parents in April 2025, completely overlooked by the judge in her analysis. And then the next change comes at 138. And we're comparing by this time 136.
Oh, a new 138.
138.
Oh, I've missed something here.
So yes, comparing with 136, which is at page 110. And the change at 138 is this. She removes, it comes after nor the size of what she saw. It seems, what she removed was just seemingly the quantity based on the foster carer's comment.
Sorry, that's a removal.
Yes. Yes, so the removal is just seemingly the quantity based on the foster carer's comment. She has not analysed the full period. Of course, the she is Dr. Dickens, this part of the judgment. And she replaces
Yes, you're right. I missed this. Replaces it with
the frequency was based on what she says were the foster carer's comments, but she has not analysed the total period. Of course, in some ways, look at what the change is, and it's about the amount of bruising. Removing quantity from that sentence. And again,
can I just try and read both versions?
yes, it's difficult.
Okay, so the premise is the bruising was disproportionate.
Yes.
That was, she said, Dr. Dickens' view.
Yes. And that was Dr. Dickens' evidence was that she, as a consultant haematologist, seeing children in clinic with their carer and observing the bruises on those children at that clinic, was that bruising was disproportionate.
Right.
And it is telling, we say, that in the original extempore judgment mentions quantity, because of course that featured in the mother's original referral.
So the reference to the frequency of bruising as one of Dr. Dickens's reasons for concluding the children bruised disproportionately was omitted from the final version of the judgment.
I would change you began that sentence with the frequency, it's the quantity.
What did I say?
You
I
said
did say-
frequency,
I
but that-
said frequency. I meant to say
Yes.
quantity, and I wrote frequency. Thank you. The quantity of bruising, it as one of Dr. Dickens' reasons for finding children bruised disproportionately was omitted from the final version of the judgment. And your point is that the supplementary point about the mother's case.
Well, the mother's case was that it was the quantity, part of her seeking that original GP
Is that
referral was quantity. We use these words,
the
disproportionate,
quantity of bruises
disproportionate.
was one of the reasons for
Yeah.
seeking medical attention.
Disproportionateness can relate to frequency, to quantity, to size, to location.
So if I followed, both Dr. Dickens and the mother were relying on quantity,
Amongst
Yes.
other things.
amongst other things,
Amongst other things,
Yeah,
yes.
yeah.
It wasn't it
as
was
opposed to
as-
frequency.
as opposed to frequency, yeah. And the judge follows that through in 140, comparing 137, because she adds, I'm sure my lord saw this one.
But by the way, just before we leave 138, there's an extra sentence as well. It's 136. Sorry, I've got it the wrong way round. I see she's moved it to 139. Yeah.
Yeah,
Sorry,
she's-
forget that.
yeah.
That's
Yes,
part of
it
the rigging which caused the confusion.
Yeah.
So the new 140,
The new 140 is comparing 137.
yeah. And what is it you're going to say? You're sure I've got?
She adds in, after he considered the logs of the foster carers and saw no pattern of disproportionate bruising,
Yeah, that's there.
but she adds in not simply frequency, but also considering location and explanation or lack of explanation.
Yes. Well, that's what I had in mind when I referred earlier to that this phrase appears is introduced at more than one
Yes.
place in the judgment. Yes.
And the next one, again, and it's not quite the same wording, but it's my lord's point about the repeating the phrase about bruising. It's paragraph 144, comparing 141. And she removes, which would mirror what the mother said and concerned her in September 2024.
Which paragraphs are we comparing?
Sorry, paragraph 144, comparing 141.
Now, I've got some words added there.
Yes, so, but she removes which would mirror what the mother said and concerned her in September 2024. And what she adds in is, again, considering location and absence of explanation, which would replicate or even be even similar to what the mother said concerned her in September of 2024.
Well, the latter amendment doesn't seem, my part, to be significant, but your point is it's adding the location, absence of explanation.
Yes,
Yeah.
and it's the choice of words, but again, it's what we say is the misrepresentation about what in fact the mother had been saying in September of 2024.
Yeah. Now you're coming to new 146, I expect.
Yes,
147.
yes, 146 and 147. These were the a summary of the questions and answers from the judge to the father at the conclusion of his oral evidence. And
So these were the points to which the judge was referring when she asked for those notes
yes, and
for Mr. Goodwin.
And at that hearing, she asked that part of the note of evidence to be read out to her.
Yes.
And of course, fundamental to that, and it's all part of the same points that we make, that the parents were only seeing the children at that stage, it was twice or three times a week, I'm not certain, but for contact. And fundamental to the parents' case as a whole was that the continued bruising in foster care was, that the bruising had continued in foster care. And of course his contact was not daily,
No.
couldn't be daily. And of course at contact, you wouldn't see each child without clothing.
What's your submission about this edition?
Well, the submission is that what the judge should not, once she's delivered a judgment, then add in a small part of the evidence that she has chosen to support the conclusions that she's made, and not least, and this is probably the main plank of our appeal, is that when there has been no proper evaluation of the parents' evidence as a whole, the parents do not singly or collectively warrant a heading in this judgment. The other witnesses get a bold heading, the parents do not. We don't know from the judgment what the parents' evidence was. We don't know what impression she formed of the parents.
For my part, it could certainly be argued, with some force, I think, that one can't be too prescriptive about how judges write judgments. I think there's a danger that we have been in this court over the years. You can't be too prescriptive about how judges go about writing judgments. And if it was the case that the parents' case was fully and fairly set out, evidence was fully, fairly and sufficiently set out in a judgment, dotted about the judgment without references to, without being set out neatly in one block, then that wouldn't be a ground for an appeal,
It
would
would
it?
not, and my lord knows that I am rarely in this court.
Well, I don't think. I don't.
Rarely in this court, because there are a range of judgments that one receives at first instance, and it's exactly as my lord says, that it may not be a perfect exposition in the way that other judges are able to put.
I don't think the fact that you're not. I don't think the fact you don't come to the court of appeals very often is relevant to that point.
No,
in
it's
respect,
not, but it's a recognition of my lord's point that the parents cannot discern how the judge reached the conclusions that she did, bearing in mind the evidence that she has. The guardian cannot.
On this point, I think you have to demonstrate at some point, not necessarily taking a huge amount of time, what parts of your case or the parents' evidence was material parts were omitted.
Yes,
So you'll come to that in due course.
yes, and I will.
Okay, so we've got to 147.
Could I just ask at 146? I understand your point. This is selective. It doesn't affect the evidence as a whole. But as far as it goes, did it accurately reflect what the father said? Because there's this use of the word increase, and she says about the same number as before the increased bruising, and then adds the words in brackets, i.e., before September 2024. Is that what the father said? Is that what the judge is inferring he meant?
Yes, I mean,
Sorry,
yeah,
the latter or the former?
this is what the father said in answer to questions from the judge at that time. But of course, and then the judge inferred from that.
So, i.e., before the September the 2024 is not what the father said. And was he asked to clarify?
No, that's and there was this was an agreed no, but he wasn't asked to clarify. He was asked.
These were just the judge's questions.
At the end, to which he agreed with the propositions that were being put to him by the judge. And of course, I've made the point already in terms of there's no analysis by the judge of, even if the father was expressing this view, how it could be compared, because of course he wasn't seeing his children 24/7 and seeing them without clothes on and seeing every single bruise that they may have had.
And this, of course, leads to 147 in the final judgment.
Yes. And of course, and we've made the points about the foster carer's evidence, that the judge doesn't engage properly with the fact that it's not a criticism of the foster carer.
This is paragraph 37
Yes.
of your closing submission.
It is.
So you would say one should juxtapose,
Yes.
even if this is an accurate note, set the two against each other in the form of view.
Yes, because the evidence was clear. First of all, the foster carer didn't log every bruise, and within our closing submissions, the list of places where I cross-examined and the foster carer agreed as to places where there were bruises that he would not have documented were places that would not be a usual site for accidental bruising. Small bruises on the back, small bruises on the back of the thigh, small bruises on the arms. There's a whole range of bruises that we just don't know, because the foster carer was very clear he wasn't documenting or had not been told to. There's no criticism of him. Then there are some changes, and I'm sure that my lord has them in 148, but I don't propose to take my lord to those. Perhaps looking at 155.
New 155 or old 155?
New 155,
Yes.
because it is relevant to assessment of the parent, because it's in the context of the allegations, the domestic abuse, but it's her analysis as to whether or not the parents were lying in their police interviews when there had been a denial of any domestic abuse, and what she adds in paragraph 155.
Which we're comparing with, I've lost one now.
Comparing 149
Thank you. Sorry.
on
Yes. Yes, go on.
113, she adds in, or at least the depth of the problem.
Yes.
She adds in, it is after it's not so much they were lying in the sense that they knew the truth and consciously tried to conceal it. It's a bit more subtle than that.
I've missed that. Where's that?
That's
Not so much that they were.
so it's not so much that they were lying in the sense that dishonesty existed. It doesn't really change the sense of it.
No, I think I didn't. I don't think it did change.
No,
That's why I didn't mark it.
it just.
Okay.
But adding in, it's a bit more subtle than that.
Okay. All right.
And then she adds in over the page. It's staying in the same paragraph. She adds in lack of insight. They're unlikely being able to do much about it. If there is dishonesty, then at least one knows there's a problem. Even if
Is that not there? If there is dishonesty, is there?
Yes, but she's not finding dishonesty.
No.
She's just
Right.
Giving
If there's a
them
lack of
a-
insight, yeah, all right. Thank you.
talking about dishonesty and lack of insight. Then at 164, back to the bruising. New 164 comparing 158. Which is the
164.
analysis.
Yes,
Yeah.
well, 164 to 167 is where there are a number of changes, which I got, I hope.
Yes. So the first change is that she adds in the pattern noticed by the mother at roughly the beginning of September, and I don't need to labour that point. She adds with before no explanation, which doesn't change the sense of it, and then she adds in so a bleeding's disorder resulting in a general pattern of odd bruising being unlikely, and then
She had since birth after, actually.
yes, and
Since
then
birth further.
the when she considers the pattern of bruising
Yes,
over time, including when events occur but with no bruising. And then the final change is in paragraph, but there is a change at 166,
Yeah.
curiously.
In all probability, our
Yes.
national is more like one parent. Yeah.
And she just removes can,
Right.
and she adds in at 167. She acknowledges the point that we had made great play of within the fact finding that the mother had taken the boy to the GP when she was concerned,
Yeah.
and that had to be improbability of doing that if there had been an injury that the mother had inflicted.
Yeah.
But adds in, but equally there is no suggestion or evidence that the father stood in the way of that. And presumably that is added in to shore up her pull finding, because the first sentence does militate against it being the mother. So presumably she added that in
Yes.
for that reason. She didn't say it.
What was your did you make a submission on perpetrator? What was your case in the event that the finding was made?
We were clear. Our primary submission was these were not inflicted injuries, and we were clear it was not us. And of course the judge deals with the fact that the mother was not pointing the finger, but that's because the mother was not accepting that these were inflicted injuries. But the overwhelming evidence, we would say, in terms of the wider canvas evidence about this mother was that there were no indicators. And of course what the court did not do, the judge did not do, was actually address what it would mean if this mother had inflicted these injuries, which of course we set out front and centre in our submissions in terms of the inherent probabilities. And it's in our overview part at page 51. And we set out what it would actually mean for these bruises to have been inflicted to the boy, for the bruise to have been inflicted to a small baby, and for a shaking injury to a baby. And we had, and although it is set out within Mr. Goodwin's skeleton, a whole raft of recordings of tensions between the parents, there was not a single recording from September through to April, 24/7 recordings that the mother had at any stage demonstrated any violence, loss of control, spitefulness towards physical spitefulness towards her children that would be relevant to the infliction of injuries. The final, there's an addition at 168, and I'm sure my lord has that, which is about halfway through paragraph 168, comparing 162, about the even with the benefit of hindsight, there's no suggestion or evidence that the bruising occurred when she was not there, or even
I
coincidentally.
know I
when the
missed
father
that. I'm
was.
sorry. Where's it comparing with what?
168 comparing 162.
It's quite late by this point. I'm sorry. So
She adds in, and even in relation to the mother, she appears to be on hand when the father was there, and even with the benefit of hindsight, there is no suggestion or evidence that the bruising occurred when she was not there, or even coincidentally when the father was.
I'm sorry, everybody. I missed that. So that you say shores up her perpetrator, her pool finding.
And then her final change is in the. There is one minor change before that, but the final significant change we say is in the final substantive paragraph 181 comparing 175.
Yes, this is the final remark.
The final remark, yes. And she removes the genius, but that's of no
Smart.
consequence. But she adds in this, it is also clear that in general the parenting appears to have been good. The judge knew that her statement that she wanted the local authority to see if there is a route home, having made serious findings of inflicted injury and placing both parents in the pool, was going to be subject to criticism. And so she added it in to justify that statement, we would suggest. And in doing so, of course, if the general parenting was good, that is not reflected in her overall assessment of the parents, each of them, in particular the mother, and the findings that she made.
If it's her view that in general the parenting was good, that was a factor, you say, relevant to her assessment of the totality of the evidence, whether the injuries were inflicted or not, and also, if they were inflicted, to the determination of the perpetrator.
My lord, yes.
And you say there's nowhere in the judgment where that is,
No.
that evaluation is
And of
carried out.
course, this is at the end having made the findings. So she's done her evaluation by this time. And of course, it is not, going back to my lord's comment as to what one expects from a judgment, it is not to traverse every aspect of the submissions made on behalf of a parent in fact finding. But when there had been a careful exposition in our written submissions about quite how often these children were taken to medical professionals, that is set out very clearly within our submissions with tables, that is part of the wider canvas and leading up to the specific referral that then put in train the child protection measures. The judge just didn't engage with that at all. So we say that those amendments do not in fact remedy the absence of proper reasoning. And as I said at the outset of that exercise, it illuminates them, and in going through it, I have of course dealt with some of the submissions that I would have been making had I not had to do an exercise. fundamental part of our appeal, and it's set out very clearly, is that the judge made an error in relation to the evidence of Mr. J.M. Owen,
Yes.
because he was the expert in relation to the subdural bleeding. The other experts deferred to him, and it is clear from the judgment that the judge concluded that Mr. J.M. Owen was saying that these were inflicted injuries, and that was not his evidence.
Do you want just to pinpoint exactly where you say in the judgment that's crystal clear?
It's paragraph 16, the first point of error. Where she summarises the whole of the medical evidence. That experts, whilst noting a blood disorder, particularly Dr. Robinson, felt it was more likely than not, the boy and the girls injuries, each of them, that it was more likely than not that they were non-accidental injuries. So that's
Can I just... Experts,
yes. So that's the
particularly Dr. Robbins.
yes, but
Okay,
That's
experts in
in
means yeah.
plural. That's all of the experts. So that's the first point, and that's the indication. And again, if that paragraph had been in there, and then when she moves on to Mr. J.M. Owen's evidence, it had been correctly set out, there would not be a ground of appeal. It would simply be an introductory paragraph that was a bit loose.
Who are the experts who deferred to this doctor on subdural bleeding?
Mr. Robinson, the paediatrician, and Dr. Robinson and Dr. Keenan, the haematologist. The
Which is why I asked the question, because that stands in contrast to the word particularly.
Yes.
Whereas that might have been true on other matters.
Yes, and they had to defer to him. He is the neurosurgeon. He is the only expert who can opine on subdural bleeding.
Yeah.
And then when we get to the judgment about Mr. J.M. Owen, it's paragraph 1. It begins at 92, but
We're now working off the new version, are you?
the new version,
And
yes, my lord.
otherwise. Okay, Mr. Jack, yeah, here we are.
And the error, because I don't need to take you through all of it, is at paragraph 1112. And just it is wrong. Because what the judge records is that Mr. J.M. Owen said in his addendum that he was sitting on the fence on matters relating to the bleeding disorder. And that's not what he said, because if we go to the large supplemental bundle, it's at 473, and I'm electronic with this. Sorry, it's not 473, it's 474.
In electronically.
Electronically.
And now we're all,
476.
what paragraph? What paragraph?
It's paragraph 45 of his addendum.
This is the third addendum.
Third addendum, yes.
Right, it's nowhere near. 45.
474, paragraph 45.
Paragraph 45.
Of
Actually, I'm sorry, I forget what I said about the third addendum. I'm confused.
line 45.
It's line 45.
Sorry,
Yes. On page 474 of our hard copy.
yes,
We should read the whole paragraph. However,
yes.
Also for paragraph.
It's at line
Line
45. It
45.
begins.
Line 4, no, 9.
Yes,
therefore, the
and-
combination of these make it difficult for me to give a clear sense of direction. Yes?
Yes.
Other than it is likely that even if an elective caesarean section has the lowest risk, the addition of forceps would increase this risk by some level. Therefore, perhaps it would be reasonable to sit on the fence and say there is, to my understanding, certainly a risk of subdural bleeding after forceps through a caesarean section.
Full stop.
And of course, this needs to be for alongside a increased bleeding tendency.
So the sitting on the fence was in relation to a birth injury.
Yeah. Yes.
And incorrectly,
Right, let's just have a look at this. We're 1112.
1112, incorrect. It's just wrong. And of course, Mr. J.M. Owen was deferring to Dr. Keenan in relation to the bleeding disorder. It's a factor as he goes on in the next sentence, and then you weigh in
Yes.
to balance the bleeding disorder.
Can we just read back in the judgment, just to get a run up to this point? In the professor's meeting, I'm reading that paragraph 111. I'm not following 111 at the moment. Perhaps we don't need to go there. You're saying
Probably
that.
not.
You're saying that. So
Yes.
sorry. The point you're making is not the point. My fault. Your point is that his conclusion on possibility of birth injury is that he wasn't able to say one way or the other.
No.
Because
Because
from
it
what he
was-
says in well, yeah,
because of the use of forceps. So he was sitting on the fence in relation to it being.
yes. Do we need to read what he said at the experts meeting and his oral
No.
evidence to get a clear sense of this?
My lord, I would say not, because it is our submissions set out, it's at page 58, that I set out that the paragraph 28 of those submissions, matters that were not in dispute. And then I set out at paragraph 29 what Mr. Jerome added to in his oral evidence.
Are we now in your
Yes,
submissions?
in my submission,
To the
sorry.
court below?
In the,
To the court below?
yes,
Um,
it's at page 58, I set out
Sorry.
paragraph 28. The matters that were not in dispute, and I note in passing that of course the list of absent features was very much longer than the judge set out in the judgment, because she only referred to the triad, but that in and of itself is not a grant,
yeah.
doesn't lend much weight, but it adds to the lack of detail that the judge applied to what was a complex medical issue.
But in paragraph 29, are you also inviting our attention to the end?
Yes, and I was
The
moving on.
likely etiologies
Yes.
are.
We're coming to that. Coming on to that now. I'm just trying.
Yes, and that was Mr. J.M. Owen's evidence. He was absolutely clear. The oral evidence was that he was not giving the court an opinion that one was more likely than the other. And of course, inflicted injury is an etiology. The judge was entitled on the evidence to make a finding it was inflicted injury, but she had to engage to do so. She had to engage with the evidence to reach that finding. And what
Okay.
she did was the shorthand of saying that Mr. J.M. Owen was saying it was more likely than not an inflicted injury. He did not.
So I just.
And my lords, my lady can see the particular part of the oral evidence that we highlighted in italics. Mr. Jayamone said to the court, and he was pressed at different points in his oral evidence about what his opinion was, the court will be clear about my degree of uncertainty in this case.
And where does the judge? Does the judge address that at all? And if
No.
so,
No, the judge, yeah, she deals with much of Mr. Jayamone's evidence. She deals with the research, the Rook-Whitby-Looney research,
yeah.
and what he was saying about birth bleeding.
So those are the three papers which demonstrated that subdural bleeding was more common at birth than was previously realised.
Yes.
We all know
Yes.
that. There's been no further research. But where does she? The judge talks in some detail about this, doesn't she? In paragraphs 40, 114, 115.
Yes. So in terms of we have where we started her statement that all of the experts were saying that these were inflicted
Yes.
injuries. We then have the error at 1112, and then we move on to the overview paragraph.
Well, I'm in 115, 116, or 115 rather, 1415.
Yes. And she acknowledges that he wasn't excluding it, but of course she'd already stated that he was saying that these were non-accidental injuries.
You mean paragraph 12?
Yes.
And the he that's being referred to throughout is
Mr. Jayamone.
Yes.
Jayamone. And I note that at the foot of the previous page there's a cross-heading addendum report,
Yes.
and the addendum report is his addendum report.
Yes.
So although there's a Dr. Robertson appears on stage briefly at the end of 112, otherwise it's
Yeah.
Jayamone. Mr.
Well,
Jayamone.
My lord, yes.
Mm.
And then the error is repeated at 164, which is the culmination of the judge's analysis.
Oh, yeah. Right. This is the heavily or the significantly amended paragraph.
Yes. The expert opinion and analysis placing unlikely event or explanation on top of unlikely explanation.
Sorry, just. What she says is that her conclusion is that that the subdural hematoma was unlikely to be caused at birth because of the time since birth and the location, and indeed the time since the birth. So, is it a fair summary, of Mr. Jayamone's evidence that, although it's possible, my phrase, it's unlikely to be caused at birth because of the time that had passed and the location of the bleeding?
We would say not, because if that had been his evidence, then he would, if it's so unlikely and then these others are more likely, but he was saying he was not giving an opinion that any of these etiologies were more likely than the other. And of course, what she doesn't address at any point in these, in the judgment, is the issue of rebleeding. If there'd been a birth bleed and then rebleeding from normal handling, which Mr. Jayamone, of course, dealt with in his evidence, oral evidence. It's a standard area of discussion with subdural bleeding. And notwithstanding the fact that she set out the page 100, sorry, paragraph 100, that Mr. J.M. Owen described that there were some areas of higher density in keeping with fresh rebleeding and seen within them, although they may represent thrombosed veins. And of course, we know that there are these uncertainties, and that was reflected in Mr. J.M. Owen's evidence.
So would it be your case that Mr. Germain's evidence could be fairly summarised as being that he was unable to say whether or not the injuries were accidental or non-accidental?
My lord, yes, and it's paragraph 31 of our written
Because
submissions.
of one. Well, what should we look rather than me write it? It's in paragraph 31.
It's paragraph 31, page 59.
Combination of possibility of birth injury,
Yeah.
Rare bleeding disorders, and possibility of rebleed. Is that it?
It is, and of course the other phrase that Mr. J.M. Owen used, and we repeated that at the top of the page about the forceps, and Mr. J.M. Owen.
Possibility of birth in context of forceps.
Yes, and his expression was, in expert hands, they are really safe. In non-expert hands, they're really dangerous. You know, he brought it alive.
Yeah.
Of course, we don't know whether these were expert hands or non-expert hands, and that is a fundamental error by the judge in the evidence, and
you would also say, of course, that in assessing that evidence, it has to be the totality of the rest of the evidence.
absolutely, and I, if you're open at our submissions, that particularly in relation to the girl, when one looks at page 54 from of our submissions, we set out almost, there were attendances with professionals throughout the girl's young life during the period where she had the bleeding. It was asymptomatic. She was being presented, and the judge did not engage with the fact that if the mother or the father had shaken the girl, then they routinely presented her for a range of issues. And our submissions in relation to Mr. J.M. Owen stand without even the complexity of the haematological evidence. And I hope the court will forgive me, because we say this is a medically complex case, but in fact we also say that there is a simplicity to that haematological evidence, which was, it was a fact that both children have two variants in relation to their blood, and neither the treating consultant haematologist nor the expert jointly instructed consultant haematologist had any experience of those genetic variants, singly or together.
And Mr. Germain had never heard of one of them.
Yes. And
There's no research.
no research, no experience. And Dr. Dickens was clear, and we say largely in agreement with Dr. Keenan, that if there was no bruising issue in relation to these children, then she would likely say, well, these are of no clinical significance. And both, we say, Dr. Keenan and Dr. Dickens agreed that the clinical picture was vitally important. And therefore brings us back full circle to the judge's analysis about the bruising and the factual dispute that she had to grapple with as to whether or not the children continued to sustain bruising post September 2024. And that needed to be analysed and resolved by the court. It was fundamental to the evidence that Dr. Dickens gave to the court about her impression of the bruising, both from what she was told, and she gave evidence about what she had been told, and by what she saw. And that had to be fully and properly evaluated and reasoned before the judge then reached a conclusion about preferring the evidence of Dr. Keenan over Dr. Dickens, we would say. And I've made a number of the points that I was intended to make about the parents' evidence in this judgment, and I take my Lord's point that doesn't necessarily require a subheading and a specific part, if indeed it is properly analysed within the discussion of the evidence. But we say that cannot be discerned from
It's
this
an
judgment.
analysis that's required.
Yes.
There's always a temptation just to recite the evidence to avoid the criticism that you haven't considered it. And part of the hopefully helpful guidance given by this court is that you shouldn't do that you shouldn't really repeat the evidence. But the important point is the analysis. And it may be in a separate section, but it may not.
It may not, but we say, first of all, there's no summary and there's no analysis. We cannot see which parts of the mother's evidence, and I'll say the parents' evidence because it will save Miss Weston repeating these submissions. If there's a difference, she will deal with it in due course. Which parts of their evidence were weighed into the balance in reaching the conclusions that she did? She didn't say whether she believed the mother's account of why she went to the doctor with the boy in September. And the really instructive part of the judgment, my submission, is this, paragraph 97. And it exemplifies the issues. I could list every reference to the mother, and there aren't many, but this is one of them, paragraph 97. And the judge sets out, it is also reported by the mother, that in August and September, that to her, the girl's head seemed bigger than the rest of her body, her weight having dropped, and the health visitor noted that the head seemed to have grown more than the rest of the girl.
Mm-hmm.
I'm sorry, can you give the reference again?
It's paragraph 97.
No, I misheard, sorry.
And going over the page, that the mother reported the girl having a startled look until about 4 months old, with large eyes, a huge protruding vein on the side of the head whenever she cried. And the judge made this comment: as far as I'm aware, none of those matters have been deemed to be significant or helpful in determining either cause or timing. So of course she's dealing with this in the context of the medical evidence. But this would have been a paradigm example where embedded analysis about the mother's actions in seeking medical attention for these features that she observed in her daughter, as being relevant to her assessment of the mother. An analysis and engagement about her analysis and assessment of her engagement with medical professionals generally, and no reference to this was but one part of the multiple medical attendances that this mother had, and then to deal with the inherent improbability of a mother repeatedly presenting her child for medical attention if she was in fact.
So she took into account the fact that her conclusion, her finding that the mother's specific complaints were not relevant to the medical issues, but didn't take into account the fact that the mother had made the complaint in determining A, whether the injuries were inflicted, or B, who the perpetrator was.
And that is one reference to the mother where it's not then pulled in and further analysed as relevant to the what needs to be done, the analysis of the medical evidence in the context of all of the evidence that is a fundamental part of any fact-finding process.
Yes.
And the only part of the parents' evidence, which of course is specifically recorded, we go back to the additions of the fathers. Not all of the father's evidence on the issue of bruising.
I mean, the passages that were
that were
we
inserted.
looked at. Yeah.
And it was fundamental to the parents' case on continued bruising that the foster carer had not logged every single bruise, and I dealt with that. And if we turn to paragraph 139, again, this exemplifies the issue that we rely on. Paragraph 139,
Yeah.
the new 139, because she separates it out, that I am grateful for the chronology which has been provided on behalf of the parents, which sets out the bruising and the timings of the bruising and the dates. Well, that gratitude just ends there because then doesn't engage with it.
Well, it does, isn't it? 140.
Well,
She says she says why. Well, she comments. That
she
doesn't,
comments on it.
doesn't
but
override the analysis by Dr. Robinson.
Yes, but when one looks at that document, it does not deal with, which of course was the parents' evidence. And if it begins at page 3 in the, not sure what we're calling it, supplementary bundle, the 110 pages.
Page 3.
Yes, and as you say, she goes on, she thanks us for it, acknowledges it. She says that Dr. Robinson had done an analysis of the full period, but then in the judgment, quite properly, says, this is 140, on the other side, the parents say because of the flawed logging by the foster care. And then what she does with that is plain at 142. She leaves aside the period of foster care for the time being, but of course doesn't go back to it.
Yes, just where's that 142?
That's 142. Doesn't go back to it at all. And when one engages with this document, begins at page 3, we have the recorded bruising that preceded the referral to the GP by the mother. We then get the recorded bruising in the child protection medical. And then when we move on, at page 5, we have unexplained bruising with supervision in place. continuing through October. Then there is bruising in November. In the context, there's some explanation of they are it's normal childhood activity, but there are marks and there are bruises. Then we have the November ones where they're observed and recorded. And there's a suggestion as to how they might have occurred, but they're not. It's not a known mechanism. It's just, well, nothing has been observed as being inflicted injury in the home because they're being supervised 24/7, but still you've got the bruises on the 28th of November. And then we have, going over the page at 7, more bruising under supervision. And then we get the first of many goose egg bruises, goose egg lumps, which occurred at nursery. And we quite simply say, and the mother says, that is disproportionate. Yes, children are bruised when they fall over, but most children who fall do not get a lump on their head like that. Bruising through February,
Yes.
March, going over the page,
Yeah.
and then of course the children are removed. 16th of April,
Yes.
the ICO. And
All this time they were being supervised. What's 24/7?
24/7.
Right. Now, how the judge? I'm hurrying you along a bit
Yes.
because of conscious time. What the judge says about this is that Dr. Robinson's conclusion, being aware of this, was no pattern of disproportionate bruising. To which she adds the phrase, not simply frequency, but also considering location and explanation.
Yes.
But was that Dr. Robinson's evidence?
That was Dr. Robinson's evidence.
So why wasn't the judge entitled to accept
Well,
it?
yes, but what the judge was doing was saying that the mother's description in September was that what happened since was different from what happened in September. And our submission was, it may be Dr. Robinson's view that there's nothing unusual about this, but the mother would say that it's part and parcel. And then, of course, we add in what has happened in foster care. And then we move on to the girl. Sorry, before I move on to the girl, because it relates to both children, of course, we have Dr. Dickens' observations in August. And Dr. Dickens was clear, she's a doctor, that had these just been toddler bruises on the shin, she would not have described them as disproportionate. She considered them to be disproportionate.
But why wasn't the judge entitled to accept Dr. Robinson's view?
She needed to explain why. She needed to engage with these points that we raised and Dr. Dickens' analysis. And of course, she considered that Dr. Dickens doesn't address that is Dr. Dickens' evidence. In our submission, we say that she disregarded that and she misconstrued the foster carer's evidence as saying, well, there's no disproportionate bruising. We don't have the full account of bruising.
But Doctor, if you're right, you may be right that the judge disregarded or doesn't refer to certain aspects of the evidence and or misconstrued the foster care's evidence. But didn't Dr. Robinson have all of that information before him when he made his he reached his conclusion?
Well, what Dr. Robinson didn't have, he could reach the conclusion on the logging under supervision, but we don't have a full log of all bruising in foster care, and that just cannot be.
Well, Dr. Robinson knew that.
Yes, but he, in saying that this is not disproportionate, he is simply adopting that, well, there's nothing being recorded.
So you're saying that what he was saying was that of the bruising of which there was evidence there was no pattern of disproportionate bruising. But
It had to be qualified by the absence of full logging. Then we have and my lords can see it, the issues in relation to we have, and Dr. Robinson, that the judge does not deal with this in her evidence. We have marks in hospital that were unexplained, and then the bruising in under supervision, and then we have similarly the at 15 and at 18 separate significant responses to knocks to the head. Now, we have to accept that Dr. Robinson's evidence was that he did not consider those to be disproportionate, but when one looks at the whole of the evidence, we say that the judge didn't engage with the counter submissions in relation to that, and indeed the evidence from Dr. Dickens, and indeed the comments by Mr. J. Moen and Dr. Keenan about that. And importantly, the judge does not engage with the fact that the local authority sought and succeeded in separating these children from the parents in April on the basis of continued bruising under supervision. The other aspect that the judge does not engage with were the records recorded by Dr. Dickens that the local authority were asserting, and it's recorded in minutes of professionals meetings in the summer and autumn of 2025, that the bruising was continuing in all settings. And the local authority didn't call any primary evidence to contradict that. And of course, my lords, my lady know from reading all of the papers and these submissions and the documents about the range of bruising, but reading the judgment as a whole, the reader would not know that there were 12 bruises recorded in September 2024, would not know about the bruising that was relied on in the ICO hearing. And even if the judge was entitled to reach the conclusion she did in relation to that bruising, what she doesn't engage with is, well, she just simply says they're inflicted. She doesn't engage, and I've already made this point about what that would mean. She doesn't evaluate whether this was a series of abusive assaults on the boy, an assault on the girl that was more likely, if it was a loss of control, to produce one small bruise is highly unlikely with a child of that age, or whether there had been an unobserved accident or a failure of supervision. She simply just moves to it is inflicted. And of course we say that her process of reasoning in relation to a full finding is woefully inadequate. And I have reached the end, my lord.
Right. Well,
somewhat longer than I thought I would be.
well, and also not by the route that you no doubt originally planned.
Thank you.
Thank you, Ms. Brown. Now, Ms. Weston, we've covered quite a lot of material, and I know your client has a similar but different case to put. But I imagine that there's not much more you want to add. Am I right?
There's not. We adopt my learned friend's submissions.
Good.
There was just one matter I wanted to come back to,
Yes, of course.
and it's the bruising,
Yeah.
because it may help for the court to take a look at what Dr. Emma Dickens said about that. So I don't know if the court has our submissions that were sent to Judge Kushner.
Well, are they in the supplemental
Should
bundle?
be.
No, that's something else.
In the yes, in the
Yes, they're
109
at,
page bundle at 66.
Yes, tab 5.
Encouraging start. So those submissions, in my respectful submissions, were quite nuanced. They were and detailed. They weren't a broad brush.
So you're
Okay.
page
Page 66.
60, oh, from the beginning.
That's right. So one of the important things to remember about Dr. Robinson, in my respectful submission, is that he was very much positing his position on the basis of the coding evidence that he'd seen. He'd never clinically examined either child.
On what evidence did you say?
On the Simon Coley foster
Oh,
care.
right, was based on foster carers' evidence.
I'm so sorry. Yes,
Okay.
Mr.
That's not to mention
Mr.
it,
Foster.
right? Okay, foster carers' evidence, right?
And we deal with that in our submissions at page 69, internal page 4 of those submissions, subheading Dr. David Willing.
Yeah.
So what that consultant paediatrician had to say was that the evidence before him was imperfect. He would have liked to see, he said, clinical descriptions, monthly assessments of the bruising. We didn't have that.
But, yeah.
And what emerged from the cross-examination of the foster carer was that he'd not been instructed to document all the bruising, but only what he considered, and I think this was described by Dr. Keenan as subjective, and what he considered significant bruising. Now that's quite important because part of the local authority's case turned not on the size of the bruises but their location. Some of them were small bruises, but it was the location of the assessment. So in my respectful submission, Dr. Robinson's evidence had to very much be seen in terms of what other material was available relevant to the clinical picture.
I haven't got to the bottom in my own mind of why the foster carer was looking for significant bruising. Was that what he was asked to do?
But his evidence was that that's what he understood his task to be.
Okay.
So
Well, a foster carer wouldn't have any idea what bruising was significant in the context of bleeding disorders, would they?
So then, if I could make reference to what Dr. Dickens' evidence was, and for this, it will be necessary to turn up the larger of the supplementary bundles. I don't ask the court to turn it up now, but father's written evidence, which was quite detailed because he'd given quite a detailed account of the circumstances in which he'd noticed his children were more or less likely to bruise. He certainly gave a lot of information there about his son's physical attributes which made him more likely to bruise in other situations. So, for instance, he noted that the number of bruises or the extent of the bruising had decreased once he wasn't in school.
So he gave a detailed description of his son's bruising.
As he understood it. So he was speculating, I think, as Judge Kushner fairly directs herself, but he, to the extent that he was able to correlate the sorts of activities or behaviour of his son and the circumstances in which that was likely to result in bruising, he's done so, and we see that from I think it's page 18 onwards. But of that bundle. But if I could ask the court to turn up page 350. So this is, I think it actually begins on 345. This is a letter to the parents from Dr. Dickens, setting out her investigations and the conclusions with her team as a treating clinical team.
Yes.
And the particular part of that document that I'd asked the court to turn up is at page 348, about halfway down the page. There's a paragraph which begins, over the time we have known.
Just about the first hole punch.
Um,
I'm sorry, I'm so sorry, you're electronic. Yes.
It's in the middle.
yeah, it's about a third of the way down actually.
Yeah.
Does the court have it?
Yes. Three-line paragraph.
It's the tendency to bruise very easily.
So that's not a snapshot, in my respectful submission. And then she also she sets out a summary in respect of the boy, beginning at 352. I'm not going to take the court through all of it, I'm sure the court will read it, it's just I wanted to highlight these specific features of that evidence.
Sorry, I missed that reference.
352, bottom of the page is where the summary begins.
Yes.
And then there's some, in my version it's in red, but anyway.
Yes, it is enough.
So in the third paragraph in red, I don't know if the court just wants to read that in light of.
Yes.
And then at 356, in respect of the girl at the bottom of the page, and with the paragraph beginning in light of.
Well, the last 3 lines.
Yes. So the court will note that it's put in slightly different terms, but obviously that summary would have to also be taken into account in terms and viewed in light of what Mr. Joe Mohan's evidence was.
Yes.
So going back to my learned friend's submission that the clinical picture, where we're dealing with Donald Rumsfeld unknown unknowns, as Mr. Joe Mohan expressed himself, the clinical picture was all important. And while I'm not pointing to every single error or omission, focus and analysis on that clinical picture was absolutely essential. And without that task being completed with sufficient rigour, in my respectful submission, the final analysis that the court has reached, and also the somewhat summary rejection of Dr. Dickens' evidence because she hadn't done a body map. Of course, it's not her job to do a body map. She gave her clinical evidence on the basis of the clinical observations she made in light of her expertise in having the children in front of her. So, in light of that, we say, and obviously adopt my learned friend's submissions and the submissions of the children's the Council of the Children's Guardian on the sort of leap to the final full conclusion. But we would say that this definitely falls into the category of case where, sort of putting it in public law rationality terms, there's a gap of reasoning between what the judge relies on and referred to and the conclusion that she reached. Unless I can assist further, those are my additional submissions.
Thank you very much, Miss Weston. Now, Miss Moore.
My lords and lady, my submissions will be, of course, very short. The Guardian's instructions are that she's neutral on the issue of the bruising, but she is particularly concerned when it comes to the issue of the potential perpetrators of the injuries that were found. Her instructions to me were very clear at the fact-finding hearing. That although she was neutral, that didn't get me off the hook, and I was to help test the evidence and call the witnesses.
Yes.
So she was an active guardian, albeit neutral in terms of the findings. The fact-finding hearing was also listed in the knowledge that she couldn't attend the fact-finding hearing, but it was to avoid further delay, that having been previously adjourned back in 2025. But what we did was have detailed notes of evidence and daily discussions as to how the evidence was panning out. So
When you say your case, so your focus is on perpetrator.
yeah,
Do you have a positive case on perpetrator which you advance on behalf of the Guardian, in the event that the finding of non-accidental injury is upheld?
well, my lord, no, not at this stage, but of course that goes to the heart of what the Guardian is concerned about in this judgment, is because the parents' evidence was insufficiently dealt with in the judgment, and there isn't an analysis to inform as to what the judge made of the parents' evidence. They gave evidence over 2 days, so in fact half of the evidence in the fact-finding hearing was from the parents, and yet there is so little of it in my submission in the judgment. So
Yes.
the Guardian is not in a position, absent I mean, she can have my note of the parents' evidence, but what she doesn't have and cannot have is the learned judge's analysis.
So
of that.
so your case is that there was evidence upon which the judge, if she was right to conclude it's non-accidental, there was evidence upon which she could have identified the perpetrator, but she didn't engage with it in the actual complaint.
Yes, and I think that's as far as we go. Of course, it may have been entirely correct that she was unable to identify a perpetrator, but until we see that in the middle of that, as it were, what her analysis was, it's very difficult to go any further with that particular consideration. I would adopt the parents' submissions that actually the judge's approach in terms of the Lucas direction, she seems to direct herself about it, but what she doesn't do is give any analysis of what a lie that might have been told, whether it was told, who told it, why they told it, and what weight she attaches to that, if any. So
Okay.
again, it's one of those examples in my position of identifying a principle but then not following it through with a proper analysis.
In the event that we dismiss this is a hypothetical question, but I'm just testing the position. In the event that we were to dismiss the appeal on most of the grounds put forward by the parents, but uphold the point you're making, so we were to uphold the judge's finding on the injuries being inflicted, but say that she erred in her approach to perpetrator, what course would you then take? Would you invite us to take? Would you invite us to, would it not follow from that we should remit the matter to this judge for review of that point?
Well, my lord, having discussed with the Guardian the way forward, because we've always flagged up that it was most unfortunate that there had to be an appeal. There's no criticism that the appeal was applied for. What we suggest is a likely way forward is for the matter to be remitted to Mrs. Justice Arbuthnot for further directions, including considerations of what is proportionate for these children.
Yes.
And
But
also
on my particular point, if we upheld the judge's finding in every respect except for perpetrator, is your case we should still remit to a different judge?
My lord, yes, because the Guardians, as I started to say, is very concerned about proportionality, but also if there are to be further welfare considerations, there will need to be updating evidence, because in this case it's particularly important what the current picture is if there's going to be well, irrespective really, whether it's just welfare considerations or whether there's going to be further considerations of matters of tax. And what the Guardian would say is at that point, the local authority will of course be under a duty to review the whole of the evidence and to decide whether in their view it's proportionate to have a complete rehearing or not. So we say there are stages to it, which for the matters raised on behalf of the parents are quite difficult to answer at the moment because of the gaps in the judgment that we have currently. I'm putting it simply and thinking about the case law on adequacy of judgments. It is the Guardian's case, but she was left not really entirely clear. Whilst it was clear what the judge has found, it wasn't clear to her why the judge had made the findings that she did. And as I said in the other documents, it's fair to say that if a guardian is left in that situation, then the parents must be too. And it's important, it's always the key plank of what a judge needs to do with a judgment is to make it clear what the findings are, what the evidence relied upon is, and what the judge's reasoning for making those findings are. So that's the Guardian's position. She was particularly concerned on the perpetrator issue because that's something that is very important to her role, both in terms of assessment and welfare planning for the children. Can I assist you any further? I promised I wouldn't be long.
Thank you very much. Thank you, Miss Moore. Mr. Goodwin.
Thank you. We seek to defend this judgment, my lord. 2 children sustained unexplained injuries in parental care against a background of unappealable findings of parental dysfunction, high stress and tension described by the judge as a perfect storm, spilling over at times into incidents of domestic abuse. There were a number of standout features in the case. I refer first of all to child B. Child A is the oldest child, A coinciding with initials.
Okay. Boy, girl, perhaps.
Boy, girl. Okay. Child B, the girl, was, as this court knows, a pre-mobile baby, i.e. not moving around, incapable of inflicting injuries on herself. And it was therefore extremely unusual for any bruise to be found on a child of that age. Second, as far as the girl was concerned, it was, to use Mr. J. Mohan's language, and I'll come back to this obviously in more detail, exceptionally rare for a subdural bleed sustained at birth to persist for the 6 or 7 months that it would have had to have persisted in this case had the girl's subdural bleed been caused that way. So exceptional rarity. So those are 2 standout features in relation to the girl, largely centred, in fact, on her age at the time of hospital admission relative to her birth, and her age in the sense that she, as I said before, was pre-mobile and therefore not capable of self-infliction. As far as the boy was concerned, it goes without saying that he was a very active child, and there were many examples spoken of in the evidence of his challenging behaviour. There was scope, plainly, for him to sustain bruises in accidents when he was playing, running around, etc. But that, of course, wasn't the end of the judge's analysis. A child with that capacity to injure himself through his activity, neurodiverse or not, may still suffer inflicted injuries as a result of parental mistreatment. So the judge had to navigate carefully through all the evidence and make decisions about the bruises that the child protection doctors and ultimately the single joint expert, Dr. Robinson, had put before the court as either being inflicted or potentially being inflicted. The third obvious standout feature, my lord, is that these 2 children had some genetic anomalies in the form of the factor 5 figures and the HSP1 gene variant. Those required careful evaluation, and the dominant feature that the judge was required to engage with was the need to assess those genetic anomalies in their proper clinical context. Again, I'll come on to that in due course. So the issue wasn't simply, are there genetic anomalies? The question was, if there is a genetic anomaly, well, does that visit itself in everyday life in the sense that it has a causative clinical effect on the child's propensity to bruise?
Just a moment.
So this judge, we say, surveyed a wide canvas of evidence in the form of evidence from the parents about histories of bruising and whether such bruising was disproportionate in different settings, evidence from the foster carer, evidence from multiple experts jointly instructed, and evidence from the clinical haematologist, Dr. Dickens. This judge, my lord, we say, was steeped in that evidence. No judgment is going to reflect every nuance advanced by counsel from whatever quarter in their respective oral and closing submissions, or even in cross-examination. The question was, or is, was this judgment good enough? And in our submission, it was. One of the questions which your lordships and your ladyship will ask yourselves is whether this judge's findings, both in relation to inflicted injury and in relation to the pool perpetrator conclusion, were, quote, unsupportable on any objective analysis. I lift that terminology from Lord Justice Ryder in Re R, one of the citations, I think, in our appeal skeleton. This judgment was supportable on an objective analysis.
Yes, I don't myself. I haven't heard Miss Brown or Miss Weston suggested it wasn't, in the sense that it was. Don't think it's part of their case that it wasn't open to the judge to make the findings. If I've misunderstood, they'll tell me quickly. Their point is you can't tell what the judge found because of the deficiencies of the judgment.
My lord, I'll move on. I'm dealing with this at a pace, not in any prejudicial way for my case, but I'm mindful of the time and the strictures.
Well, this is initial tour d'horizon of your submissions, and you'll come back in more detail at 2 o'clock.
Indeed. This is my next point. Is in relation to the different iterations of this judgment. I'm not going to duplicate anything that my learned friend Miss Brown has helpfully set out on behalf of the mother, but there's an additional complexity to the picture, probably an unwelcome complexity to the picture, which I don't think your lordships and ladyship have been addressed about so far. So, in context, the version of the judgment in the core bundle is an unapproved version. It says so, and it was. It was the original oral judgment before the judge had the opportunity to review it.
Transcribed.
Yes, and approve it. So that is an unapproved version of the judgment.
Yeah.
We now, I think, agree at the bar that the version of the judgment that has in the top left, approved by Judge Kushner on the 10th of March, is the approved version. And my learned friend is absolutely right that it came with the judicial rider in an email that the judge wanted that to be sent to the Court of Appeal. So that, we all suggest, should be treated as the approved judgment. The additional complexity I referred to a moment ago is that the judgment then went off to the transcribers, came back to the judge, and a further version of the judgment has been produced, which isn't in any of these bundles, which I think is identical to the unapproved version in the core bundle, but says approved judgment in the top left of every page and in the centre of the first page. It is not the approved judgment. It says it is, but it isn't. So I'm saying that I'm giving.
Well, you draw that into our attention in addition to the bar, Mr.
Well, I am bound. I'm bound to draw that to your lordship's attention, but in my submission, it doesn't detract from what I think is a unanimous submission from all of us that this court should treat the 10th of March iteration as the version intended by the judge to be her expression of her
So
views.
the version we've got now, marked approved, was sent to council electronically.
It was approved on the 10th, as marked in the top left, and it was sent to council on the 12th.
Electronically.
Yes.
So it wasn't as if the judge made some handwritten changes and they had to go back to the shorthand writers for them to do the amendments. She did the amendments directly herself,
Lord, yes.
which makes, I just don't understand why anyone would need to send any document back to the shorthand writers.
I can't assist with that.
No, okay.
Well, particularly since I was always brought up to believe that the judgment that's delivered is the judgment that was delivered orally and not a revision of it afterwards, except for typing errors. But call me old-fashioned. Seem to remember Lord Bingham saying something to that effect some time ago.
No, I mean, I think it's not these days not uncommon or occasional practice that there are amendments broader than typographical amendments.
Well,
Give our own judgments, for example.
my lady's observation bridges into my next point, which is a point of some significance, given how much time in this appeal today has been spent on comparing and contrasting the two versions of the judgment. And I say bluntly that this judge was entitled to review.
Well, the first one is uncorrected.
Indeed.
So you don't know how much of the changes is correction as opposed to something to reflect what she thought she was saying at the time.
What was originally in her mind,
Yeah.
as opposed to a thought that occurred thereafter.
There are two things there. One is in her mind, another is what she said.
Lord, I certainly see that difference.
But the point remains, the first version is uncorrected in any shape or form.
Yes. I say, to make an obvious point, that a judgment is simply an expression or articulation of thought processes that the judge has following the conclusion of the case, and amendments made.
We're all thinking, is that how we would describe our own judgments? Expression of thought processes.
Well,
You don't normally. I have to say, Mr. Goodwin, that it's fairly unusual for those of us who were less experienced than my lord in matters of family practice to see such a stream of consciousness being provided as a judgment of the court.
That's a slightly different point, isn't it?
Yeah,
We'll
but
come
it
back
is-
to after lunch.
It
no
really
doubt.
is a stream of consciousness.
But going back to the, so do you want to just before lunch, develop your submission on the validity, as it were, of this final judgment, which has
the judge does not render the final judgment invalid simply because there are amendments, additions, and clarifications to the judgment that she delivered orally. The judge is permitted to do that. The judge is permitted to review the final expression of her, careful about saying thought process, but the judge is entitled, surely we say, to review the way she puts that down on paper.
What if she does that, as Miss Brown, I think expressly said, certainly implied, what if she does that in the light of grounds of appeal that she's seen floating around?
Well, this court would have to find that she had done that and she had added information that had not been part of her original thinking at all, as opposed to clarifying and adding information that was part of her original thinking but hadn't been put on paper or hadn't been read out.
And
that
it could be
is an
said,
extremely difficult task for the court.
I hope we don't have to get stuck into this on top of the main substance of the issues, but I suppose you could make a strong submission that she's entitled to do that if she hasn't approved it, and people have filed submissions grounds for appeal on the basis of an unapproved judgment, why shouldn't she take it into account? It is unorthodox, but I mean, do you go so far as to say that, or or are you just?
I'm not, maybe I'm ducking the question, but it's really difficult to respond to that, my lord, because it assumes that that was what the judge was doing. And none of us in this room knows whether the judge was retrospectively insulating her judgment from the threat and appeal, as opposed to articulating
What
thoughts
was in
that
her mind?
What you do
or
know, though,
even
is
said?
that she did not articulate those thoughts orally.
I do.
That's the one thing that we can all be certain of. I mean, it's one thing to create an infelicitous expression to show that you haven't when you're extemporizing, that you haven't quite, it hasn't come out quite as you intended. It's another to excise whole passages and put new ones in.
Well, for the reasons that I'll address, if I may, at 2 o'clock, none of the additions to the judgment undermine the basic reasoning and structure and the conclusions of the original. They may supplement it, they may clarify, they don't undermine it.
Can I, before we break, just if I may, unless you want to come back, can I just, one thing, it's referred to in the papers, but I just can be clear with this, the way in which the judgment was prepared, I think we're told that it was delivered ex-tempore from notes.
But we,
Is that right? Is that right?
if I may,
Yes.
I think have formed that view. Although we couldn't see exactly what the judge was looking at, it was fairly obvious that she was using notes and delivering an oral judgment based on notes. She certainly wasn't reading out a verbatim written draft. That's very clear.
Yes. Well, whether that is likely to lead to a greater latitude to be or to amendment in the revision process is something one might consider. Anyway, you're nailing your colours to the mast is that the changes, that there were no invalid changes, my word, not yours. You're going to develop that at 2 o'clock.
I'm not at 2 o'clock going to run through every single highlighted amendment.
No, but I mean,
between
the
two.
ones that was, apart from the Ms. Brown highlighted, and I think the ones which you will need to focus on.
Indeed, and I will. Thank you.
Thank you very much. Right, thank you all very much. I think we're on target still.
Absolutely.
In time. Thank you very much.
Court rises
2
able.
o'clock. Thank you.